Uno, dos, one, two, tres, cuatro.
Hey, welcome back to Rethink Your Legacy. This is Francisco Sorrent, founder of Keystone Law Firm. Today, see what's on the screen? We're going to do something real exciting. We're going to look at the law. Ugh. What we're looking at here is Title 14. This is the main source of law for probate and estate planning. Title 14, maybe there's obviously some others that are relevant too. There's the tax section, there's the real estate section, there's the health and medical section. But this is all relevant. It's just pieces of the other ones that are relevant. So I want to introduce you guys to Title 14. If you're in the middle of facing a probate issue right now, somebody has passed away and you don't know what to do, I invite you to call. You can call the number below. You can click and schedule your free discovery call. My team would be happy to chat with you, figure out what's going on. At the end, there'll be a little video you can also click to that'll link right on this video. You'll see it pop up towards the end. That will tell you a little bit more about that first appointment, what happens, and how to get that help, okay? Title 14 is it. Our firm, we limit what we do just to things that are either avoiding having to go to court under Title 14. That's our estate planning stuff. Or we are helping families go through it when necessary. It's not a fun thing to have to go to probate court, but when you need to, you need to. There's no other way around it. And why would you need to? Generally speaking, it comes up only a couple different scenarios. It can happen in two different time periods, and those would be the two different kinds of probates that we run into. The first that can happen in someone's life is if you become incapacitated, and you'll see down there, Chapter 5, it says protection of persons under disability. Yeah, so that's the first probate, and that can happen a couple different ways. Either somebody has become disabled and they need help taking care of themselves medically. They can't communicate their wishes, or they don't necessarily understand what's happening, and so they just can't communicate reasonable wishes. And that might be because they've been disabled for a long time as a kid, and they've now turned 18. So you might need to go to probate to become their guardian. Or maybe it's an elderly parent or spouse who has dementia, had a stroke, and did not have recent healthcare power of attorneys in place. So there's nobody legally designated to decide when they should go see the doctor, what type of medical treatment they should have, where they should live, all those things. And so you might need a guardian for that. Or a conservator if there's money that needs to be managed. Sometimes that happens if there's an accident, there's going to be a settlement payout, or they're just elderly again and they need help managing their finances. We had one guy whose wife, her dementia got bad to the point where he had to place her in a group home, and they had their primary home, they had a rental home. He needed to sell the rental home in order to keep paying for it. He didn't want to manage being a landlord anymore. And he went and got it under contract with a real estate agent, went to a title company, and then the title company said, sir, this house is titled under you and your wife, community property right of survivorship. That's a joint title. We need both of your signatures. And he said, oh, well, yeah, no problem. Like we're joint, like it's right of survivorship, so I can sign for both of us. And they said, no, that only happens after she dies. Then right of survivorship goes to you. Then it's just you. She's still alive, so she needs to sign. And he's like, and so they said, do you have a power of attorney for her? And he said, oh, yes, I do. He went and dug back through their records, found this old power of attorney and gave it to him. And they said, that's a really old power of attorney. We can't recognize that thing. That's just too old. We're not going to honor it. We don't want to take the liability of something not being valid in that. And so we can't recognize that. So she can't sign. The power of attorney is not valid. The only other way you can sell this house is by going to court and having the court give you the authority to sign for her. And that's what a conservatorship is. And that's why probate gets involved, even if you're alive, even between a married couple. And I've talked about that process on the show before. We'll have to do some more training on it as well. But that's sort of where probate can come in while you're alive. And then after, if someone passes away, probate comes in. If you have no will, very likely you need to probate something. If you have a will and you need to use it, a bank, a title company, if you're trying to sell a house, or just all kinds of things, they're not going to look at a will and say, oh yeah, that's okay, good, it says it goes to you, here you go. They're not going to hand it to you. They're going to say, great, take that will to probate court and then bring us the probate court document that says this is valid. That's what they're going to say. The bank is going to freeze the account. The title company is not going to transfer title. And you're going to be told, go to probate. And so then you got to learn all these statutes, or you got to call someone for help. That's what we do, of course, if you don't want to figure it out yourself. You can see each one of these chapters just has dozens and dozens and dozens of probate laws. Talk about complexity. Most lawyers don't even touch this stuff. They refer it to us because they're like, I tried, it got rejected and my client's mad at me. So here, please just help. And so that's what we do, of course. It also governs what happens with trust administration. So if you are a trustee for someone, then you've got to know what's in here. You'll see that Chapter 7 and Chapter 11 deal with trust administration, and the Arizona Trust Code. Both of those lay out how responsible you are, how much you have at risk if you take on that job. Same thing as an executor. You're signing on personal liability for doing the job correctly. If you don't do it correctly, the laws here say you have to fix the mistake, even if it's an honest mistake. And that could end up costing you tens of thousands of dollars out of your own pocket to fix the mistake. The thing that you want to know before you go into this and accepting that job is, if you do need to hire and pay for advice from a law firm, those fees are allowed to come out of the estate or the trust off the top, so it's not fun to have to do that. But if you just want to make sure it's done right, you're allowed to use those funds that are in the estate, that are in the trust, to hire and ask for help. You're completely allowed to do that. If you're the executor, if you're the personal representative or the trustee, you can do that. And that's what we're here for. That's why I give you the option to call and get yourself scheduled, or click and get yourself scheduled for that first appointment if you need that help. Don't try to navigate this alone. There's a bunch of gotchas that you may not know about until after the fact. We had one gal who called us. This was years after her sister died. Smart lady. She called and she's like, I'm the manager of a bank. I mean, she was a smart gal. And she said, I did all the probate stuff myself when my sister died and got it all done. And now I got a letter from some lawyer who claims to represent my sister's long lost ex-husband. And he's showing me legal documents saying I got to pay him a bunch of money. Help. We reviewed everything she did in the original probate, and we had to come back to her and say, yeah, you missed a couple steps. And so we're going to have to deal with this guy. We're able to negotiate, a reasonable way out for her, but she wouldn't have had to deal with him at all if she would have just done everything, all of the little steps along the way. So don't miss that stuff. Don't end up. And she, of course, had to pay for this all out of her own pocket because the estate was gone. All the money was gone. And so it was just, it sucked. She had to do this and deal with it. But, so be it. She made the mistake and she knew she had to deal with it. So just don't do that, right? I recommend you learn this stuff, get your questions answered, and that way, when you get to the end of the probate, and even if you are a beneficiary yourself, if you've distributed money to you or to the others who are the beneficiaries, you can say to them or even to yourself, the money is done. Like, what you're getting is free and clear. There's nobody who can crawl out of the woodwork and try to unwind or claw back or make a mess for any of us, including the IRS. You don't want some tax bill popping up later that says, oh, now you owe the IRS some money. So, so that is why I want you to know about the Title 14. This is where all of the laws are regarding trust estates and protective proceedings. Get to know this stuff, or make sure that whoever you work with knows this stuff inside and out. I think that's all I had for today, guys. Welcome back to the show. We are live and online with YouTube, so you'll start to see all of these shows accumulating here on the channel, as well as the old ones. We have some already posted, and you'll be invited to come back and see as we keep adding more and more. Take care, everyone.